A trivia question for you. The US Army's 6850th Internal Security Detachment was the only Allied unit in World War II whose insignia featured which symbol? Have a guess. See if you can have a go in the comments. You might get a clue from the fact that what I want to talk about now is the defence of "I was only obeying orders," the so-called Nuremberg defence. Although, as we'll see, this goes back way before Nuremberg. So let me take you back to 1472 and a guy called Peter von Hagenbach, who was put on trial for war crimes by the Holy Roman Empire. And it was things like, massacring civilians, things that YouTube doesn't like me talking about, and for some reason, perjury. But his defence was, well, I was just obeying the orders of my boss, the Duke of Burgundy. And, as a knight, that's my duty. And they said, no, as a knight, your duty is to be all chivalrous and protect the innocent. And that overrides any duty you may have to your master. So, sorry, mate, you're convicted, off you go to be beheaded. One thing in medieval times, though, that they, generally speaking, they let off the actual, average soldier, because they were usually just levies raised by their sort of lords and masters, and they didn't want to set a precedent for, your average peasant to be challenging their superiors. So that was always the convention. The posh people, the aristocrats, they could be executed or ransomed off, but everybody else, it was just like, okay, just go back to your farms now. And also, it was a bad idea to sort of massacre all your workers if you, wanted some crops that year. So moving on from that, now bring us up to sort of, the modern era. And it's a guy called Oppenheim, not the bomb guy. Oppenheim wrote the sort of definitive textbook on international law. And in the 1906 edition, he had this to say: "In case members of forces commit violations ordered by their commanders, the members may not be punished, for the commanders are alone responsible, and the latter may, therefore, be punished as war criminals on their capture by the enemy." In other words, you can't go after the squaddies, you can only go after the commanders who actually gave the orders. And this cropped up after World War I. As part of the Treaty of Versailles, the German government were obligated to try their war criminals. So they had a series of trials called the Leipzig trials. And one of the cases was a U-boat commander who had sunk a civilian ship. And his defence was, hey, I just get told by the Admiralty what the targets are. I've got no idea why I'm sinking them. I don't know what the intelligence is. I don't know what's going on at, above my pay grade. So that's my defence. And you might remember at the time there was a lot of controversy about whether civilian ships were transporting munitions and troops and things like that. But he was acquitted. They said, yeah, fair enough, it's not for you to sort of second guess your superiors in that situation. Now, the Western powers, it's fair to say, were a bit annoyed about that, but they couldn't really complain that the Germans weren't treating this seriously and just letting off all their citizens, because they did actually convict in a lot of cases. Somebody was put on trial for firing on people in lifeboats, and he said that's the standard policy, that's what we were told to do. And that was rejected. They said, no, everybody knows, especially seamen, that you don't fire on people in lifeboats. That's bang out of order. You have committed a war crime, so you are guilty. Incidentally, it's a war crime to shoot at somebody parachuting out of a stricken aircraft, but it's not a war crime to shoot at paratroopers. Okay, so if you're ever in that situation, as you're coming to Earth, yell out, "My plane's blown up!" But we move forward, obviously, to World War II. Now, we've all heard about the Nuremberg tribunals, but there were lots of other tribunals as well. The Allied powers, as the occupying powers, they took over the legal system, and they actually tried a number of people well before Nuremberg, including, there was a German general who had carried out the Führer order. That was the order from Adolf Hitler that said any commandos captured are to be summarily executed and not treated as prisoners of war. And his defence again was, I was obeying orders. It's literally called the Führer order. So what was I supposed to do? And they said, well, no, that is a breach of the Hague and Geneva Conventions, and every soldier knows that, and it doesn't matter what your boss told you. So he was basically, he went to the firing squad. But But when it came to Nuremberg itself, okay, there was a bit of sort of kerfuffle as to exactly what format these tribunals should take. Churchill just wanted to do what we call a Bill of Attainder and just say, pass an act to Parliament saying, here's a list of people who are to be executed. Stalin said, no, 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 we want a big show trial. However, it should be guilty until proven innocent. In the end, they came up with a format, and part of the problem was, we've discussed before about the difference between common law and civil law systems, and so which one do you use? In the end, it was the trial will be done under the common law system. In other words, each side gets their own lawyers and they choose what witnesses to call, what evidence to present, what case to run. But we won't have a jury like in a common law system. We'll have a panel of judges like in a civil law system, and they will determine both the law and the facts. But as part of Nuremberg, it was explicitly said that the only obeying orders, superior orders defence would not apply. Now, interestingly, actual German law at the time, which actually dated back about 100 years, that also excluded the superior orders defence. So they could have actually prosecuted most of the Nuremberg defendants under German domestic law, and that was briefly considered. But even though it got a few mentions in the actual Nuremberg tribunal, they didn't. In the end, they just went with this. This system. But what's the position today? Well, the International Criminal Court has an article, Article 33, which is called Superior Orders and Prescription of Law, which reads as follows. The fact that a crime within the jurisdiction of the court has been committed by a person pursuant to an order of a government or superior, whether military or civilian, shall not relieve that person of criminal responsibility. So there you go. Well, the defence doesn't apply. However, there's an unless. Unless A, the person was under a legal obligation to obey orders of the government or the superior in question. B, the person did not know that the order was unlawful. And C, the order was not manifestly unlawful. And there's a little caveat there that says, for the purposes of this article, orders to commit genocide or crimes against humanity are manifestly unlawful. So what does that mean? Well, consider two scenarios. You're a squaddy in your regular armed forces of your country, and you are sent off to war. And you're out there, and it's just like, normal war conditions, and you don't commit any individual atrocities. But it transpires that the war is illegal. Do you commit an offence? Actually, no, you personally do not. The jurisprudence is quite clear on that it's not for you to second guess the politics of this. And this actually cropped up where some people refused to serve in the Gulf War. Some of it was conscientious objection, but some people said, well, hang on a minute, this is an illegal war, or at least some of the politicians are saying it is, and I don't want to risk being nicked for a war crime. But the courts there, the court-martial here said, well, actually, no, because you would have this blanket defence, so you wouldn't be committing a crime, that means refusing to obey that order is a crime, and they were actually convicted by the court-martial. But what about the other end of the scale? Certain types of ammunition are illegal. Okay, expanding ammunition is illegal. But squaddies are not expected to be experts in ballistics or wound characteristics. It's like you just get the ammo, you just use the ammo that's given to you. And again, that is a defence. You cannot be held liable just because your equipment breaches the Hague or Geneva Conventions. Okay, so that's two scenarios. I mean, this all does get a little bit complicated because we don't have one international sort of tribunal. There's the International Criminal Court, but not everybody's just signed up to that. We've had sort of, the Rwanda, Yugoslavia ad hoc tribunals. There's going to be tribunals coming up possibly about all the sort of Russian thing. And they all have slightly different procedures. I mean, for instance, even if they adopt that test, what's the burden and standard of proof? Is it for the prosecution to prove that the person, knew the order was unlawful? Or is it for the defence? Do they have to prove that they didn't realise the order was unlawful? And, what's the standard? Do they just have to raise it? Do they have to prove it on the balance of probabilities? Do they have to prove it beyond all reasonable doubt, etc., etc.? So, it's a relatively complex issue. And this, by definition, this can only be a very brief overview. But I hope you did find that useful and interesting. If you did, please consider clicking the like button, subscribing and sharing. And yeah, thanks for the comment that inspired this. And like I say, have a go at that trivia question and I'll check out in the comments if anybody got it right.